application. So how is the applicant actually entitled to this invention and to lodging the application for the invention, for the patent? Another is the Form P26, which is a declaration that the invention is related to indigenous, traditional, or biological resources, or that it's not. So just some of the few documents that are required in support of an application. Your P3, which is the declaration and power of attorney, needs to be filed within 6 months of filing your complete application, as well as the Form P26, which is the document relating to indigenous or biological or genetic resources. Your assignment documents or proof of the applicant's entitlement can be filed anytime before the acceptance of the application. So that is within 18 months. So within 18 months of filing your complete application, the application needs to be in order for acceptance. That is, all formal requirements must have been complied with. These deadlines between filing the application and between it being accepted are extendable upon request to the registrar. So you can make a formal application where the applicant requires more time in order to obtain the documents. In instances, an inventor may have left the employer of the applicant and then can't find the inventor. So they need to trace the inventor to sign certain documents, just as an example, and they may need additional time. Another reason why the acceptance deadline itself may be extended is purely because of the reason that South Africa doesn't conduct substantive search and examination. They will await examination in a counterpart application. So oftentimes applicants will file concurrent applications in the various countries where they seek patent protection. So they'll file the complete application in America, they'll file a complete application in Japan, in Australia, in Italy, and they'll await examination from those examining countries to see what the examiners have found during the examination process of the substantive aspects of the application. And then they will align the South African application to conform with the changes that are made in counterpart applications to ensure that at the time the South African application proceeds to grant, that it is in a valid form. Is everyone with me there? Okay, I hope so. Okay, so once all formal requirements have been met and the application is in order for acceptance, the Patent Office will then issue the acceptance notice, and that is the Patent Office stamp of approval that the application may now proceed to grant. Once the application is accepted and the acceptance notice issued, the acceptance of the application needs to be published in the patent journal. And acceptance has to be published within 3 months from the date of acceptance. If the acceptance is not published in the patent journal timeously, the application lapses and you've lost all your rights in relation to the South African application. So this is a very critical deadline to monitor. So if within 3 months you fail to publish the acceptance notice in the patent journal, the application lapses. It is possible to request an extension of this deadline. However, the request must be made before the expiry of the 3-month time period. And there is case law on this, which we'll look at a little bit later on. Okay, then your monopoly, the time from which the life of the patent runs and from which you have enforceable rights once the application is published in the patent journal and it is granted, the date of publication being the date of grant, your 20-year monopoly runs from the South African filing date. Yeah, so that is basically looking at the instance where it's a South African application with a South African priority. But the same process then is followed should you file a Paris Convention application that comes from a foreign country and conversely, filing a South African application in a foreign counterpart. Are there any questions regarding this slide? It's a very important slide. These deadlines are critical, and you'll all see from the past papers that these questions do crop up in terms of the timelines.
Hi, Michael.
Yes.
That 3 months that you have within which to publish the acceptance, and as you mentioned, you miss that, you lose all your rights. There's just no way of resuscitating that, like as a, you know, when like in renewals where you have at least 6 months to pay your late penalties and all of that.
Yes.
In this case, there's nothing. Is it like done? It's done.
Yeah, look, it's done. And that's in terms of the act, and also what case law holds is that the application has then lapsed, so you don't even have granted rights, even if you do go ahead and publish. Look, the judgment itself, and we'll touch on the judgment a bit later on. In practice, a lot of practitioners feel that the judgment is incredibly onerous and incredibly harsh and unfair towards applicants, especially if the missing of the publication wasn't on the applicant's shoulders. You know, it could have been an administrator that never scheduled the date, for instance. You know, it's quite a harsh penalty to lose your rights purely by missing that date. So what I have seen happen in practice is that the applicants will then request the extension to publish. So this deadline, yeah, they'll request that extension after the fact. So even though they've missed the 3-month deadline within which to file that extension, they will still apply for it. And in some cases, the registrar may allow it. Whether he's permitted to allow it is a different question, or whether he's applied his mind to allowing it is also another question. So in that instance, if it has been allowed, you know, the registrar can then be taken on review should somebody wish to attack it on this basis that there isn't actually any granted rights. You know, so it is a risky approach to take, but that is what happens in practice, is that the extension will often be requested, or not often, because this doesn't happen, hopefully, too regularly. Although I have seen it happen, you know, from people that have transferred cases to me, where I have seen that those dates have been missed. So it does definitely happen, and that is the approach that is sometimes taken to try and save the rights. But in terms of the act and in terms of what the case law says, the application is lapsed. But it's then upon another party to show that the registrar acted out of the ambit of his duties by allowing that request post that date.
Thank you. It sounds harsh indeed, but
Yeah, it really is.
yeah.
I mean, you can imagine all the development, all the planning that's taken place, and just because of one step like that, and I mean, it's an administrative step, they can lose their rights.
Cool.
Yes, Jerry.
The journal itself, is that the publication, is that managed through the patent's office, or is there a different process?
Yes, so that's managed by the patent office. So the trademark acceptances also get published in there, and the designs. It's just referred to as the patent journal. And what it used to be overseen by the government printers when it was still a hard copy of the patent journal. So all the acceptances would be sent through with the publication details to the government printers, but it is an electronic document now. So the submissions are submitted to the patent journal by a specific date, and they then do the compilation and the publication of the patent journal. And the patent journal ordinarily takes place the last Wednesday of every month. Okay. It might differ in April and December, considering all the public holidays and patent office closures, but ordinarily the last Wednesday of every month. So the practice that we have within our firm is that once the acceptance notice is received from the patent office, we schedule publication for 2 months after the date. So we never look at the 3 months. We always publish 2 months, except in exceptional circumstances where clients want grant speedily. Then we'll look at publishing the following month.
Okay, thank you.
Okay. Are there any further questions regarding this process?
Hi, Marco. It's
Hi,
Andre
Andre.
again.
Yes.
It's not a very substantive question, but I suppose on the practical side, if you have a client who wishes to pursue a certain invention or whatever the case may be, and you have then filed a provisional application, would you then advise that client that it is essentially safe to start monetizing his invention at that stage already? Because I suppose he can't disclose it anymore because he now has that priority date. So would you still recommend against that, or would you say that it's relatively safe to start, I suppose, marketing, even advertising your invention after the provisional date?
Look, they can go ahead and start manufacturing and putting it onto the market. The only thing is they won't be able to enforce any rights. So if somebody is infringing them during this time period, yeah, there's nothing that can be done about it. So it all depends on the risk that they're wishing to take. You know, you can only enforce your rights once the case has gone to grant and from the filing date. So you can disclose, but it is still quite a risk to, in terms of potential infringement to go ahead onto the market.
No, okay, thanks. No, that definitely makes sense. Thanks.
Okay. And even once you'll see, I'll mention it later, but we can touch on it now. Even once your application goes to grant, you can't institute infringement proceedings within the first 9 months from grant, unless there are exceptional circumstances, and you have to, in those cases, actually request condonation for the institution of infringement proceedings. And that has to be done by the Commissioner of Patents. So, you need to apply to the courts to actually grant you this lift of the moratorium, that 9-month moratorium.
So, Michael, can you just explain that again? Why is there a moratorium after grant?
Why is there a moratorium? Look, I think it's to give due notice to possible third parties, basically, to ensure that, had they been conducting an infringement, to possibly seize and desist. But I think that's the main reason, is purely because it's sufficient time and notice to the public that this patent has now granted, and just to act as a notification, basically.
Wow. Okay.
Yeah.
Thanks.
Yeah, if we then move on to the PCT and national phase applications. So we have looked at the PCT in quite a bit of detail already, but again, you'll file your provisional application, or you can omit the provisional application altogether and file your complete application in the first instance at the PCT stage. In terms of the Paris Convention, Article 4, the 12-month time period also exists from the date of filing your provisional application and filing the PCT application. So you have to file your PCT application within 12 months from the priority dates. And that's your earliest priority dates in terms of the Paris Convention. The same as you would in terms of a complete application coming from abroad. Okay, then ordinarily within 16 months from the priority date, you'll be issued with your international search report and your written opinion. This is all during the international phase now, where examination takes place. And that is one of the greatest benefits of filing an international application, because you receive this search report before filing applications across the world and before expending, vast amount of money or large sums of money in obtaining patent protection. So, by filing one application, you are issued with a search report and written opinion, and that acts as quite a clear guideline as to whether, it is worthwhile pursuing further patent protection in various countries or not. Okay, then within 18 months from the priority date, the international application is published on PatentScope, which is the WIPO's website where all patent documents are published. Okay, as I mentioned earlier this morning, there is this optional step to file a demand. That is where you are filing an amended set of claims or any amendments to the specification in light of the response to the examiner's objections, should he have found that a claim was lacking novelty and inventiveness. So just as a simple example, the examiner might have found that the first claim of the of the invention is deemed to lack novelty. However, the second claim is found to be novel. So in order to ensure that your invention is valid and has novelty, you would amend your second and first claim to incorporate it into one claim, because there is in the second claim novelty to be found. So by combining the first and second claims, that entire claim is then deemed to be novel, because remember, you only need one novel integer to give you novelty. So that will then be filed, or an entire new set of claims will be filed, and those are again examined during the international phase, and then your international patentability report is issued. If there is no demand that takes place, your ISR and written opinion is the equivalent of your IPRP. But if there is a demand, your IPRP will be issued. And then it's up to the applicants to enter the national phase. So at this stage, they will instruct their agents across the world in the various countries to enter the national phase of this international application. Okay, so they'll just send through the PCT application number to the applicants and say, please file the national phase of this application, and the local agent in that country will then go ahead and enter the national phase. And then it will run the same life and undergo the prosecution of the country in which they entered. Okay. So, in some countries, there may again be examination that takes place. For South Africa, there's no examination, but the formality requirements still need to be complied with, and so on and so forth. Just important to note is that the filing dates of the South African application when it enters the national phase is actually the PCT filing date. So the monopoly will then run from the PCT filing date and not the national phase filing date. Okay. So the effective filing date of the South African application is actually the international application's filing date. Jerry, you happy? You seem perturbed.
Yeah, I was just thinking, this is when we don't file the South African one, we first file the international and then come to South Africa. Is that correct?
That's correct, yes.
Okay, all right. So the previous discussion doesn't apply in these cases, which was the
Complete.
complete, yeah.
Yes, that's right. So it's two separate processes. So the first one is either filing applications directly into South Africa or via the Paris Convention. Okay, so from the international arrangements we spoke about this morning, the Paris Convention provides for that right of priority where you can then file an application abroad within 12 months. So that's what the previous slide dealt with, is those types of applications. But national phase applications are applications that are filed in terms of the Patent Cooperation Treaty, where there's an international application, which is then later entered into the various national countries.
And the previous case, are they typically used by South African citizens? Or do we also get them from overseas?
So it works both ways. So ordinarily that process is followed where they do not wish to seek, global protection. They might want to obtain a patent in 2 or 3 countries. So it's cost effective to then file that route. Whereas,
the diamond exploration example.
yes, exactly. Whereas
Okay.
with the PCT application, the benefit of it is that you're obtaining a written opinion from the examiner before even expending money in various countries. So, you can decide at this stage whether to pursue applications globally or not. And it's also easier than to just enter national phase in the 157 countries that are member to the PCT. Look, I've never seen. Yeah.
Yeah, just for interest sake, and maybe the others are interested, what sort of costs are we talking about?
For the filing of a PCT application.
Yes.
So to file the PCT application, it depends on which country is the examining authority, but you can look upwards of about 100,000 Rand for the PCT application. And then you still need to pay, when you enter the national phase, all those further prosecution costs as well. So you'll still need to pay the attorneys in every country to file the application, to respond to objections, to file documents, etc. So it becomes a very costly exercise.
And the examination typically happens at WIPO, or is it happening in country where you lodge it?
So you would actually elect in your PCT application who you want to examine the application.
Okay.
So various patent offices are examining authorities, and you would in that application then select yourself who you want to examine. And those fees also vary depending on those countries. So you can do it cheaper depending on which patent office you select to examine the application.
And these PCT applications, do we in South Africa have an examination body? I know there were some trials run. Is that what you're referring to, or is it different?
So we don't conduct the examination in South Africa. So ours ordinarily done by one of the foreign jurisdictions.
Okay.
There is at WIPO as well, the IB, which is the International Bureau, which also is able to conduct examination. And they sit at WIPO itself. So it's not from a specific country. Yeah.
Thanks. May I come in there?
Yes.
You talked about the fact that the date of filing is likely to be the filing date for the PCT application, something like that. But in the case in which your priority date for the PCT application is drawn from your provisional application, probably within South Africa, I think that also becomes the date of filing. Am I correct?
No. So if there's no provisional application filed, then your filing date of your PCT will be your priority application date as well. So it will have the same filing date for the PCT application, and also for the priority application, because that will be your priority application. So the national phase, or the filing date of the South African application, is always going to be the international filing date. It's never the provisional application filing date.
That is in case where you don't have a provisional application filed, right?
Even if you have a provisional application filed, your filing date is always your international filing date.
Oh,
Okay. It's the same as with the completes. Your filing date for your complete is the date that it's actually submitted at the patent office. It's not the provisional filing date. The provisional filing date is only looked at when the courts assess the novelty and inventiveness of the invention. And, to consider at which date to look at what would constitute prior art. But in terms of filing dates, it's either for completes the actual lodgement date at the patent office, and for national phase applications, it's always the international filing date.
okay, thank you.
Okay. And you'll see that this becomes relevant when you have to look at the payment of renewal fees. From when do those renewal deadlines run? But
Yeah.
we'll touch on those. Okay. Okay, everyone happy with the first two slides, and we can move on. Good. Okay, this is quite self-explanatory. We can just go through it briefly. Not much that's of substance here, but it just says in section 31 that an application for a patent shall be made in the prescribed manner. So that is completing the correct forms and on payment of the prescribed fee, and shall be accompanied by a provisional specification or by a complete specification, depending on which type of application you're filing. Does anyone know what the prescribed fee is for a complete specification in South Africa? Complete application. What does it pay? What do we pay the government?
590.
590, that's correct. Okay, so the fee to the government for the patent is 590 Rand. Not very much. Then in terms of Regulation 22, it says what shall accompany the application. It says that the application for the provisional or complete must be made on Form P1 and must include Form P2. Form P2 basically sets out the bibliographic details. So what is the title of the invention? Who are the inventors? What is the date on which the application is lodged? Which applications do you claim priority from? And that ultimately becomes the register page. So the patent register that is available to the public with all the bibliographic details, which is available online. The Form P2 essentially forms part of the register. Then, as I mentioned earlier, you need to submit your declaration and power of attorney, which is on Form P3, an assignment document or other proof of the right of the applicant to apply for the application, and I'll touch on these in a bit more detail later. Then, if it's a provisional specification, you need a cover page, which is Form P6, or for complete, it's Form P7. And that just includes the bibliographic details, the title of the invention, the classification, and so on. Then any drawings, if necessary, and an abstract, as well as a Form P8. And in some instances, a publication drawing is also submitted. Your Form P8 and your abstract is what gets published in the patent journal once the application is accepted. So the details from here is what is published in the patent journal. Then, since the amendment to the Act on 14 December 2007, it's also necessary to lodge the Form P26, as shown here in Regulation 22, and that is just a statement or a declaration made in terms of whether the invention claimed is based on or derived from indigenous biological resource, genetic resource, or traditional knowledge or use. Should the application relate to traditional or indigenous biological or genetic resources, then further provisions apply, as can be seen in section 33B of the Act, where proof has to be given to the registrar of the applicant's entitlement to actually make use of the indigenous biological resource, genetic resource, or traditional knowledge. Okay. And what proof is required can either be bioprospecting permit in terms of Chapter 7 of NEMBA, proof of consent that was obtained, a material transfer agreement, a benefit sharing agreement, a co-ownership agreement, should the traditional knowledge be, or the community from where the traditional knowledge is derived, be cited as an applicant to that trust, or any other proof to the satisfaction of the registrar. Okay, a very important provision in terms of South Africa, considering the medicinal properties of indigenous plants that we have in South Africa. One of the examples where this would have been relevant, but was prior to the amendments to the legislation, was when the CSIR had extracted the compounds from the Hoodia plant and formulated it as an appetite suppressant, as a pharmaceutical medicament to, basically as a diet pill to suppress people's appetite. And that was something which was traditional knowledge within the Khoisan group of people, that in times of drought would actually chew or eat the plant and help them to suppress their appetite so that they didn't feel the hunger pains. And that is something that the CSIR had exploited and benefited from. And unfortunately, I don't believe that community had benefited from something which would have been considered traditional knowledge. Okay, then if we have a look at the proof of the applicant's entitlement, so you have to show as the applicant that you are the proprietor of the invention, that the invention belongs to you, and Regulation 23 provides an assignment or other proof to the satisfaction of the registrar. Sorry, this is in terms of the right to claim priority. I'm mixing it up. So if we take a step back, so it could happen in instances where Company A filed a provisional application, but Company B now owns the rights to the provisional application. So you have to show that Company B is entitled to that priority application. So there has to be an assignment or other proof that the rights are transferred from Company A or to Company B. Okay. But before that, there will also then be an assignment of invention, where the invention itself has been assigned to the proprietor or the applicant, being the company. And this can be either by way of an assignment where there's a written agreement. It could be in terms of an employment contract where your employment contract provides for the transfer of rights, of intellectual property rights. It can also be in terms of common law, for instance, in South Africa, where inventions devised in the course and scope of your employment belong to your employer. In those instances, because it is by operation of law, inventors will ordinarily sign a confirmatory deed of assignment, which just confirms that the rights have transferred. Because if it's by operation of law, there's no physical evidence that that transfer had taken place. It's purely by the way that the law has developed and prescribed that transfer to take place. Okay, then you also need to file, if it's a South African patent application that comes from a South African provisional application, you need to file a copy of the provisional application in that instance when you're completing it. And if it's from abroad, so if you're claiming a foreign priority from the US or Japan, whatever the case may be, a certified priority document. So it must be a certified copy of the priority application in the foreign jurisdiction. And then also it needs to be translated into one of the official languages of South Africa. Yeah. Yes.
Thanks, Mark. I want to ask this question relating to genetic materials, particularly like in the case you gave with the CSIR. Let's if that this plant material, just like you find it in that area you're talking about now, you still find it in other places apart from this local community. You find it in 1, 2, 3, 4, 5, 6 local community, and sometimes across the border of one country.
Yes.
Will you still will it still be expected that such communities are contacted? Are we still going to consider such material as indigenous to a particular community?
No, it has to be confined within the borders of South Africa. So it has to be indigenous to South Africa. So, you know, like an aloe plant, for instance, could probably be found all over in Southern Africa and possibly Australia and places like that as well. It's not really indigenous to South Africa. So it has to be confined within our borders.
Okay. And now I'm still asking, even if in that scenario, you have it in about 2, 3, 4 communities, are we still mandated to get all those communities involved, or it has to strictly be belong to one singular community?
If it's within South Africa, so if all those communities are in South Africa, you're saying?
Oh, okay.
No, I'm asking you a question. So if all those communities are in South Africa, is that your question?
Yes, if all those communities now are in South Africa.
Yes. Look, you'll probably need to, it becomes tricky because you'll need to establish where that knowledge originated from traditionally. You know, who was the first established community to utilize that knowledge? I don't know the exact answer to be honest with you, but that's what I believe would have to take place, is that an investigation will have to be done to conduct, you know, is it actually, you know, where does it originate from? And I mean, if it's amongst various communities, then is it still considered indigenous? I think it has to be localized to a specific community. That's what would make sense to me. Sorry, I don't have a black and white answer for you on that one, but that's what would make sense. Is that it wouldn't really be considered indigenous anymore.
Okay.
But we can have a look at the definitions of that.
Sorry, I just wanted to say maybe that could be also, I guess, related to geographical indications somewhat.
Yeah, look, a geographical indicator acts more as a source identifier, so along the lines of a trademark, to identify, you know, where the origin of that product is. But I guess it could possibly be analogous to it, except there's nothing really attaching to it. It's just to allow for that community to benefit from their traditional and indigenous knowledge.
Thanks, Mr.
Yeah, then, yes.
Just on the terminology, the terms provisional application and complete application, has it any bearing on the specification, complete specification?
Yes, so With the provisional application, the application itself doesn't need to include a set of claims. So you just need to describe what the invention is when filing your provisional application. Your complete application, though, needs to include your set of claims, because that is what will essentially be granted and what the court will look at when determining the scope of your protection, where your monopoly sits. So that's the distinction between the two.
The reason I ask, I just quickly looked at the Act itself. There is no reference to the words provisional or complete application. So I'm just a little bit confused.
Yeah, let me have a look at that.
So there's a lot of reference to provisional specification, complete specification. So the application
Those are terms that are used in the Act. It
Okay.
might just not be defined itself.
Provisional application.
Just go back. Okay, I see. You see, so if you look at section 31.
31.
You see, so section 31 does refer to it being accompanied by either provisional or a complete specification.
Yeah, there is no reference to application. Hence my
No
question.
specification, yeah. So look, when I'm referring to application, it's an application for provisional application. So where you're just obtaining your priority dates. And your complete is what is filed within 12 months from your priority application. And your complete is where your granted rights are established from.
Yeah. The point at which I got confused is when you referred to the application date. So correct me if my understanding is correct or wrong. The application date is not based on the provisional application. Is that what you mentioned?
That's correct. Yes.
Okay.
That's correct.
Okay. Got you.
That's
Yeah.
correct. Okay. So your provisional filing dates is solely the dates by which novelty and inventiveness are assessed by. So anything before that is considered prior art, forms part of the state of the art.
And also the priority date is based on the provisional or not?
Yeah, so your priority dates is the provisional's filing date.
Okay,
Yeah.
so the three relevant points are the priority date, the novelty, and the inventiveness is based on the provisional.
Yes, that's right.
Okay, cool. Thank
Okay,
you.
To confuse it a bit even further is that you can file multiple provisional applications and claim priority from all of those. So that would happen in instances where further developments have taken place over a specific invention, and an additional provisional application is then filed to include those new features. So then your complete application will claim priority from both provisional applications. Okay.
From all the previous provisional applications.
Provided it's within the 12-month period within which you can claim priority. Okay. Okay, so then, again, looking at the date, section 35 says that the application shall save as is otherwise provided for in this act, date from the day on which it is lodged at the patent office. Okay, and then there is the exclusion for national phase patent applications, where express provision is made in the act that the date of lodging the national phase application is in fact the international filing date. So how do you go about obtaining your application number? What are the minimum requirements to actually obtain a patent application number? Well, you have to pay your 590 Rand. You have to complete the form P1 or P25 in the instances of national phase patent applications, and you need to submit your specification, and then also any drawings to go along with that. But if it is a convention application, so an application in terms of the Paris Convention, then it's not required to file the specification upon filing if you are claiming priority from an earlier filed application, but you do need to submit it within 14 days of filing the application in South Africa. So if it's a convention application that claims priority, you just need to pay your fee, you need to lodge the application form, and you will be issued with your patent application number. Okay. But if it's an application that doesn't claim priority, then you do need to submit your specification upon filing as well. It's also possible, in an instance where an application comes from abroad, that it was filed in a foreign language. So let's take Germany, for example. The priority application was filed in Germany in German, and they now wish to complete it in South Africa, but they haven't undergone the translation into one of the official languages of South Africa yet. Then you can lodge the foreign language specification. So you can lodge the German specification, but you are required to submit the English translation within 3 months of the filing in South Africa. That is only for Paris Convention applications. For national phase applications, you have 6 months within which to lodge the English translation of the spec. And then provision is also made for the amendments of the priority claim. So you can amend your claims to priority within 2 months from the filing dates. To be honest, I've never seen this used in practice, and I'm not actually 100% certain what the reason for this provision is. I haven't come across an instance where you would need to amend the priority claim. Okay, then if we move on to looking at national phase applications in terms of section 43E, as I said, you have to enter the national phase within 31 months from the earliest priority date of the international application. And in order to obtain your application number for the patent application, you need to pay the fees to enter, or for the patent office to accept the application, and then also lodge the translations with the patent office. Okay. Again, very similar to the previous provisions. Instead of a Form P1 being used, as is the case for Paris Convention applications, Form P25 is the application document that is submitted to the patent office. As I said earlier, not very riveting work this, but we do need to go through this. Okay, any questions regarding the applications so far?
Could you please, Marco, could you please go back to the previous slide? And could you please just explain the 3 months and 6 months with reference to the German example you used? Okay,
so if it's a complete application, so the application was first filed in Germany in German language, and they then wish to file in terms of the Paris Convention, they can file the German specification for South Africa, but they need to submit a translation within 3 months, from the filing dates. But that's only applicable to Paris Convention applications. However, if it's a national phase application that comes via the PCT, then they need to submit the English translation within 6 months. So there's an additional 3 months from the local filing dates in South Africa. Because the international application can be filed in Germany, it can undergo examination in German, and the specification in the international phase will also be published in German. So by the time they come to South Africa, there may not be any English translation available yet. So they can file what was lodged in the international phase, but within 6 months, you do need to submit your English translation of the specification for national phase applications.
Okay. So just I'm a little bit confused with the Paris Convention application, the PCT application. I was under the impression that the Paris Convention is normally when you go directly into South Africa by a German company. And in this example, you mentioned it was also filed in Germany. That's what's confusing me.
Okay, so what would happen is they'll file the priority application in Germany, and that priority application will also be completed in Germany. So
Okay.
the complete application that will be filed and is prepared for Germany will then also be filed in South Africa. So the specification is prepared by the German applicant, and it's ordinarily the same specification that will be used in Germany, which is then filed in South Africa.
Okay, so maybe to ask my question differently, why would the German company not have preferred the PCT application? Why did they just go for the Paris Convention?
Look, it will depend on what their interests are, whether they want to pursue global protection, if they want to, wait that
just
long.
a smaller. Okay.
Yeah,
Okay.
yeah.
Okay, got you. Thank you.
Okay. The PCT phase also takes much longer because it's 31 months from the priority dates in which you only file your application in South Africa. Whereas if you're filing a Paris Convention, it's within 12 months. So, it's also a time benefit or a time disadvantage depending on what the applicant's requirements are.
Okay. All right. Okay, thank you.
Okay, section 31, we'll just briefly have a look at this. This states what applications you can claim priority from. The first one obviously being you can claim priority from a previously filed application that is a provisional application. So an application that's accompanied by provisional specification, if we look at the wording from the Act. But you can also claim priority from a complete application. So it doesn't need to be a priority application. So, if we go back to the German example where if they didn't file a provisional application, they filed a complete application in the first instance, you are still entitled to claim priority from the complete application that was filed in Germany. Okay, so as I said, you can file directly. You don't need to file provisional applications. And this is basically just the distinction that is made here, that you can claim priority from both a provisional application or a complete application. Again, this is just setting out the timelines that you need to claim priority within 12 months of filing the application. Yeah. So if we have a look at it, it says an application in a convention country that you can claim priority from, provided in claiming priority, the prior application was lodged not earlier than 1 year before on payment of the prescribed fee or not earlier than 15 months before the date of the application. But as you may recall, this is only applicable to South African applications. Then in claiming priority in terms of paragraph C, the application in the convention country was lodged not earlier than 1 year. So this is in respect of an application where you're claiming priority from a foreign application. So there's no provision here for the extension of the 1 year period within which to claim priority. And then also you need to show that the proprietor is entitled to that prior application. Okay, then sections 31 to A to C states basically that an application from which priority is claimed must be the first application for that subject matter in a specific country. You might wonder why this provision is here, and it does arise, especially in the United States, where what they do is that they file continuation applications. So they'll file an application, they'll modify it, they'll file another application, they'll modify it, they'll file another application, and they're all these continuation applications that stem from an original application relating to an invention. And then when the application is filed in South Africa, you know, that first filed application's filing date is long gone. It may have been 5, 6, 7 years already, but they're claiming priority then from the continuation application, which may not be the first invention or first application in respect of that invention. So there might be an issue in those instances with whether or not there's a valid claim to priority. So just something to be mindful of, and this has also been a contentious issue in litigation in South Africa, which is known as the Benz judgment. Okay, but say in the instance where you have filed a provisional application and have filed further applications, the way that you can claim priority from those later applications is that the prior application must have been withdrawn, abandoned, refused. You know, so this might be an instance where an applicant has filed a priority application, but they decide not to complete it. They need additional time to further develop it or to acquire funding, and only later on wish to then complete the application. So they need a bit more time. So then they either need to withdraw the priority application or they must allow it to go abandoned. Okay, that's basically that. Yes.
The example you used regarding the US process of filing multiple provisional applications. Are they required to abandon the earlier ones or not?
No, they're not required to. And they're not necessarily provisional applications. They, in a lot of instances, they complete applications as well. So they complete it and then add either new subject matter or they file basically divisional applications from that application.
So in those instances, in those instances where it's not abandoned and they try to lodge an application here, but our law says you need to have abandoned them, how do we handle that?
So in those cases, they wouldn't have a valid priority claim in South Africa because the subject matter doesn't relate to the original invention, or not necessarily the original invention. So what you would do in that instance is you'd ensure that the South African claims contain new subject matter that wasn't filed in the originally filed US application. So there must be some difference because, you know, so long as the claim subject matter in South Africa is not identical to what was originally filed, then there shouldn't be a problem. Because the novelty will come in where the further applications contain that subject matter. But it becomes quite complicated. But that is generally what is then done in South Africa. So you'll either delete the claims that are identical in totality, or you'll amend it in such a way that you introduce matter that was not disclosed in the first application, so that you don't need to have reliance on that priority.
Okay, and then I'm just thinking, if a South African tries to lodge a patent based on the first provisional application, would he succeed?
Sorry, can you repeat that for me?
So a South African tries to lodge a patent application on the first provisional application. Would he succeed here, or would that be considered as part of prior art?
Look, it depends on whether that actually was published. If that specification was published, then it would be considered prior art.
Okay.
Yeah.
Okay. All right. Thanks.
And in those cases where it has been completed in America, that document would become prior art. Even the priority application becomes prior art because the entire file is published. So no, you wouldn't
Okay.
come right.
Okay. Cool.
Okay, so what do we need to include in the patent specification? Now, as you know, the patent specification is a document that describes the invention. It sets out the steps taken to obtain the invention, the results, similar to a scientific paper, that has your materials, your methods, and then also your claims. And the claims then obviously define the scope of protection. So it says that every specification shall indicate whether it's a provisional or complete specification, and that is done by either lodging a Form P6 for the provisional or a Form P7 for complete specification. And that shall then commence with the title of the invention, which sufficiently describes the subject matter to which that invention relates. So just a brief title as to what the invention is. Then your provisional specification shall fairly describe the invention. As I mentioned earlier, provisional specification isn't required to include a set of claims because there's no granted rights, so you'll never be able to rely on a provisional application to enforce any rights in terms of infringement proceedings. Your complete specification then must have an abstract lodged with it. It must sufficiently describe, ascertain, and when necessary, illustrate or exemplify the invention and the manner in which it is to be performed in order to enable the invention to be performed by a person skilled in the art of such an invention. So the disclosure, as I mentioned earlier this morning, must be an enabling disclosure. It must enable a person skilled in the art to actually perform that invention. If it doesn't, then it could be a ground for the revocation of the patent, as you'll see tomorrow when we look at the revocation proceedings. So if you don't sufficiently describe the invention or the way that it needs to be conducted or performed in order to obtain the results that it sets out to teach, then you have this situation where it is insufficient, where the specification is deficient in actually teaching how to perform the invention. And in that case, you can revoke the patent. Hi, Neil.
Sorry, Marco, just a question. Is there a word limit on the abstract? I'm looking at a past paper from 2015. I can maybe just paste the question. It was a multiple choice question.
Yeah.
And one of the options was that a complete patent specification should have an abstract generally limited to a single paragraph of not more than 150 words.
Mm.
Is that true or not?
Yeah, that's correct. So the patent regulations prescribe that the paragraph must be 150 words. It cannot be more than that. But to be honest with you, I often see abstracts, coming from abroad where it's nearly a page long. And, it is accepted. It's not rejected on that basis by the patent office. So although it is legislated, it is a regulation. I don't think any weight is really applied to it in practice. And I know the patent office isn't concerned by it. I think it stems back from when the patent journal was physically printed, where it was hard copies, so you couldn't have abstracts that were 1 page long each, because you'd have to print thousands and thousands of pages per patent journal. So it was just to limit the size of the patent journal. But now that it's electronic, I don't think much weight is added to that because there's no printing, there's no cost involved in printing the actual patent journal. So it's quite an outdated regulation, but the correct answer is yes, it's limited to 150 words.
Okay, thank you.
But nothing happens if it's more.
All right.
Okay. And then, as you can see, your complete specification also needs to end with the claim or claims of the invention. And that essentially is what the courts will always look to when establishing whether the invention is novel or not. And then what is the requirement for the claims? You know, there's no set structure as to how the claim should be written out. There's no set structure as to how specification must be set out. It's all things that have evolved in practice and, you know, taking from foreign jurisdictions where there are guidelines on how it should be done. The only requirement in terms of the act as to what the claim should look like is that it must relate to a single invention. So you can't claim more than one invention, although that does happen. It must be clear and it must be fairly based on the matter disclosed in the specification. So what you are claiming must relate to the subject matter in the description of the specification. Okay. So what is in the claims must also be within the description itself. This should be basis for what you are claiming. And then also in terms of microorganisms, to remember that you are required to submit the accession details as to where those microbiological deposits can be obtained from. If we then move on to regulations 67C and D, you also then, if it is in a language other than one of the official languages of South Africa, you are required to submit that translation, okay, of both the description, the claims, and any drawings with that. Again, a lot of what we've touched on here, so I think we can move past this. As I mentioned to Jerry and to the rest of you earlier, but stemming from Jerry's question, is that you can claim priority from multiple applications. It's not just necessarily from one application. Just want to have a look at how we're doing for time. Yeah, I think let's just break for 5 minutes until 2:30, if that's okay. And then we'll pick up from conversion and post dating again. Okay, see you in 5 minutes. Thank you. Welcome back, everyone. I think we can then move on to the next section of the procedural aspects of obtaining a patent application and related procedural steps relating to applications for patents. So having a look at section 38, provision is made for the conversion of a complete application to a provisional application, provided that the request to convert the complete application into a provisional application doesn't take place more than 12 months after the filing date of the complete application. Obviously, if you do follow that route, you do need to ensure that there are no rights that are outstanding or any rights that are lost. So within 12 months of filing a complete application, you can convert it to a provisional application. Then it's also possible to post-date a complete specification where you request that the filing date of the complete application be pushed forward. So you'll specify the date to which you wish the complete application's filing date to be post-dated to. But no application for the post-dating may be made later than the dates, later than 6 months from the date of which the application is lodged. So if you do wish to post-date a complete application, you have to do so within 6 months from the filing date of the complete application. Obviously, you can't post-date a complete application where you no longer have a valid claim to priority. So should you wish to post-date the application, you must ensure that the post-dated filing date does still permit you to have a valid priority claim. So you can't post-date in an instance where the priority filing dates and the complete filing dates are more than 12 months apart. And then also you need to ensure that there are no rights that are left outstanding, so that nothing would lapse or that it would become abandoned or void. And the reason why people may wish to post-date is that the applicant might want more time to put his application in order to increase the duration of the length of the term of the patent, although the effective date would essentially be the post-dated filing date. There is a risk that the applicant runs by post-dating a complete application because there's no guidance as to whether a post-dated filing date would be recognized by foreign jurisdictions. So should they wish to file an application in a foreign country and claim priority, will that date be considered a valid filing date or not? You know, and then also there's also the potential that there could be an intervening novelty destroying event between the date of post filing and the date on which the application was actually filed for that complete, in the instance where there's no priority claim. Then a lot of what we've touched on earlier already is the examination process that takes place in South Africa. And this is set out in section 34 and regulation 40 of the patent regulations, that an application is examined purely on the basis that it complies with the requirements in terms of the Act, and that's solely whether the formal requirements have been met. In terms of the provisional application, it's only examined to ensure that the documents lodged in respect of it are actually legible and capable of reproduction. So quite an archaic provision relating to provisional applications. Again, looking at the dates, something that you can look through in the slides, but what we have already touched on, and the same applies with the following slide. From the first slide that we discussed earlier regarding the filing process, where I gave the overview of the complete filing process, I mentioned that an application should be in order for acceptance within 18 months from the date of filing the application. That time limit differs for national phase applications. For national phase applications, the application needs to be in order within 12 months from the filing dates, the local filing date in South Africa for the national phase application, as opposed to 18 months for complete applications. If the formal requirements aren't complied with and no suitable extensions of these deadlines have been requested, then the application is deemed to have lapsed. You are able to file an appeal in the instance where you believe the application has lapsed due to non-compliance with the formality requirements. It does often happen in practice due to constraints on the resources at the patent office that they are unable to accept an application within these timelines. In that case, the application doesn't lapse because it's no fault due to the applicant. It's purely due to administrative delays that the applications aren't accepted within the respective timelines. So as you can see there, if the delay is not due to any act or omission on behalf of the applicant, then the application does not lapse. As I said, these deadlines are extendable upon request. You are able to request a 3-month extension of each. In the first instance, that first 3-month request doesn't require any reason. So it is a request that will be granted automatically upon application. It's an extension by right, basically, that you are able to request a 3-month extension without providing any reasons. Any period beyond that, beyond the additional 3 months, any request for an extension beyond that does require that good cause be shown to the registrar. So in the application to request this deadline, you would set out the reasons as to why you're requesting an extension of the acceptance date. So if you request that the acceptance date be extended by an additional year, the patent office, if allowed, will not accept that application until that time has passed. And as I discussed earlier this morning, the most common reason why you would request these extensions is to ensure that the South African application is in valid form, pending the outcome of examination in foreign counterparts in other jurisdictions. Yeah, then Regulation 44 basically just sets out that if the registrar is satisfied that the requirements have been complied with, he may then accept the application and give written notice.
One more question.
Yes.
Just the previous slide, the 18 months in the example of the German application, we have 18 months to lodge it here. Is that correct?
No, not to lodge it here. So you've got 12 months within which to lodge it here. Remember, in terms of Paris Convention, you have to file your complete within 12 months. But once it's filed, so from the South African local filing date, you have to have your application in order. So all formal requirements must be completed within 18 months. And the patent office
or
then
12
has to,
months, yeah.
Or 12 months for national phase application.
Okay, got you. Thanks.
Okay. So I do know it's a handful of deadlines and things to take into account, but when you work through this in your own time, it will hopefully become a bit clearer and not too confusing. It is a lot of information. So once the case is in order for acceptance, there aren't any pending delays of the acceptance deadline. The patent office will issue you with a notice of acceptance, and as I said in the initial overview, it has to be published within 3 months from the date of acceptance in terms of Regulation 46. And as you can see from section 42.3, unless acceptance is published, the application shall lapse. And this is just an example of what the acceptance notice looks like that is received by the applicant from the Patent Office. It includes the date on which it was accepted, and within 3 months of that date, the application must be published in the Patent Journal. Fortunately, the Patent Office has made improvements and strides towards being more efficient with electronic databases and resources, and we are now receiving these in electronic form, which is really great improvements and very beneficial to the practitioners. Okay, a very important case to note, and you would have seen that I have touched on this case quite often in the past examination papers. That's the University of Pretoria versus the Registrar of Patents case, which specifically looked at these deadlines regarding the publication of acceptance and also the acceptance deadlines. In this case, the acceptance of the application was published outside of the 3-month deadline, and no extension was made for that publication dates. So that 3-month period from the date of acceptance to publication in the Patent Journal is extendable if the request is made before it expires. And in this instance, the case wasn't published within the 3-month period, and there was also no request made for the extension of the publication date. And the court had held that the application had lapsed. Furthermore, the application was also not placed in order for acceptance before the 18-month period. So the 18-month period had expired. The case wasn't in order for acceptance because the formality requirements hadn't been complied with. And a request was made after the 18-month deadline by the applicant to extend the period within which to place the case in order for acceptance. And the court held that the registrar acted out of office in that instance, and that extension should not have been allowed. So it is believed that whenever there is a deadline, the requests to extend those deadlines should be made prior to the expiry of the dates on which it would expire. Okay. So if we just look at the points that I have set out in the slide. So if at the dates when acceptance of a patent application is due, and there has been no request for an extension of the acceptance period, the patent application is not in order for acceptance, the application will lapse. There's also no possibility of extending the period for acceptance further after the date when acceptance due has already passed. And this is because of the peremptory wording in terms of section 40. So you can have a look at section 40 in your own time. Then also the wording of section 42.3 is also peremptory, which says that the application shall lapse if it's not published within the prescribed time. So unless acceptance of a patent application is published in the Patent Journal within the published prescribed period of 3 months from the date of acceptance, the application shall lapse. And then the court also held that it's not possible for the registrar to extend this period unless an application for the extension has been made by the applicant on good cause shown and the prescribed fee has been paid before the 3 months is up. So very harsh judgment, quite onerous on the applicants, and severe consequences and repercussions if those deadlines are not complied with. Okay, so when does the official file at the Patent Office become open to public? When is it officially a public document that the public can access? And this is set out in section 43.1 to 43.3. So if it is a South African application that stems from a South African provisional application, that application will only become open to public inspection once it has proceeded to grant. So as at the date of grant, it will then become a public document. But that is only in instances where it is a South African application with a South African priority claim. It's also applicable in instances where it is a direct filing into South Africa with no claim to priority. Then it will also only become open to public inspection upon grant. If it is a Paris Convention application that has a claim to priority, then the file will become open to public inspection within 18 months from the earliest priority date. Okay. I hope that's clear to everyone. For national phase applications, those applications are published within 18 months of the earliest priority dates of the international phase application for the PCT. So when those applications are filed in South Africa, they are ordinarily already open to public inspection. Sections 43.4a to c, you are able to just go through that on your own time. Section 44 then touches on the grant. It says that the patent is to be sealed as soon as practicable after publication. So that means that the patent office should soon after grant, or as soon as they are able to issue the letters patent document, so the patent certificate to the applicant. Also bearing in mind that the date of publication of acceptance in the patent journal is the dates on which the application has granted. Again, also what I touched on earlier is that infringement proceedings may only be instituted 9 months from the date of grant, unless the commissioner grants leave to institute the proceedings, provided that good cause is shown. So practical example would possibly be where there is an imminent threat of infringement, where the product is being imported, that there's proof of the importation, or the manufacturer. You can seek leave from the Commissioner of Patents to institute proceedings. Then just as an example to show you what the patent journal looks like, the cover page of the patent journal, along with the publication of acceptance. So you have the application number, you have the priority date, the application filing date in South Africa, then also the classification. So, in terms of searching, conducting searches, each invention is classified according to the subject matter to which it relates, who the patentee is, as well as the inventors, the priority application details. So you can see that this claim priority from a United States application, the title, as well as the abstract, and then a publication drawing.
Martha?
Yes.
This, what we have on screen, is that a typical publication by the patent applicant? Or
Yes.
is it after the grant done by the patent office?
No, so this is what is published by the applicant. So once the acceptance is issued, these are the details of the acceptance notice and the publication particulars on Form P8. So this date here, this May 2017, here we go, 31 May. That would have been the date of grant of this application.
Okay.
Yeah. So the publication of these details is an indication that it has proceeded to grant.
And this is what I would do in that 3-month period where I publish it in the journal.
That's correct. Yes.
Okay, thanks.
Sorry, let me also come in. There are
Okay.
3 mentioned here: acceptance, publication, and grant. Can you please come again on those 3 things? What are the differences? Thank you.
Okay. Okay. So the acceptance is an indication from the patent office that the application has met and has complied with all the requirements to obtain a granted patent in South Africa. So they then issue the acceptance notice, which is a stamp of approval that the application is in order and may now proceed to grant. So it's after they've conducted the examination in terms of the formal requirements that need to be complied with. So have all the supporting documents been lodged in respect of that invention, or in respect of that application. And the acceptance notice is then issued. The acceptance notice is, again, as I said, just a stamp of approval that the application complies with all the requirements in terms of the Act. Then in order for it to proceed to grant, you have to publish that the application was accepted along with the specific publication particulars. And the publication is also analogous to grant, because the date on which it is published is deemed to be the date of grant, and that is the date from which the rights are granted to the patentee and from which it's enforceable. Does that help you, Adeyemi?
Yes, very well. Thank you.
Perfect. Right.
And this is just within 3 months, right? The 3 of them are within 3 months.
Yes. So from acceptance within 3 months, this process must take place.
Hi, Marco.
Yes, Jerry.
So between the publication and the grant, is anything done by the Patents Office or is it automatic?
No, so the publication indicates that it's granted. So there's no additional steps to be followed. So publication basically in South Africa equals grant.
And is there any certificate issued on grant, or is it the acceptance the same as?
No, so let me just check. You may recall earlier this morning I showed you the patent certificate.
Yes.
It had the ribbon with the South African flag's colours.
Yes, yes.
So that's
yes.
the certificate that's then issued. And as
When?
you see,
Is it on acceptance or on grant?
No,
That's
so it's on grant, but
okay, so okay.
You see, in terms of Section 44, it says the patent is sealed and must be issued as soon as possible after grant. However, because there are delays and inadequacies in terms of resources at the patent office, the patent certificate is only received approximately a year after grant.
Okay.
Okay.
And then
look, I must say that there have been massive improvements at the patent office. So the turnaround time is decreasing, which is really, really great to note. And there's, we recently appointed a new registrar of patents, and he's really, driving processes, driving efficiencies, and making massive strides at improving the efficiencies of the patent office. And honestly, I can commend him for the work that's being done at the patent office.
And the notification on acceptance, is that just maybe an email or something like that?
Yeah, so previously it was issued in paper form. It used to be sent to the firms in paper form like this, but now they've recently started issuing it electronically, so you receive it via email.
Okay, cool, yeah. Thanks.
So it looks a bit different to this one, but the contents is the same. Is everyone still happy to continue for the day, or should we pick up tomorrow again? I'm happy to continue if you'd like. Otherwise, we can move over to tomorrow.
Yeah, we can move to tomorrow. It's fine.
Okay, let's see. I think we need a. If I can ask, if you can just raise your hand if you want to continue today. We'll go with the majority. I wonder if the others are even in attendance still.
I would recommend that we do poll that as well.
I agree. Okay, so we had 11 hands to continue tomorrow. Yes,
question.
13. Yes. Okay, well, I think it seems like there's quite a few hands that says let's continue. It won't be much longer.
Let me add mine.
We won't go past 4 o'clock, so I'm happy to carry on. Ademi, did you have a question? Yeah, I can't hear you.
Yes. No, I was asking what your question is because I can see people are raising hands here.
No, my question was whether people wish to continue for a little bit longer, and I think we will carry on just for a few more minutes until we finish this chapter. It should be about 5 or 6 more slides then. Okay. Okay, so we've discussed provisional patent applications, we've discussed complete patent applications, and we've also had a look at national phase patent applications. But in terms of Section 39, there's also the provision for the filing of what is known as a patent of addition. And a patent of addition is applied for where there is an addition to, an improvement to, or modification of the invention. So an application has already been filed, a complete application for an invention, but after conducting further developments, there might be some modification or improvement or addition to the already disclosed invention. And in that instance where there is an addition or improvement or modification to the invention, the applicant is able to apply for a patent of addition. Now, a patent of addition can be applied for when the parent application, as I'll refer to it, or yes, let's refer to the first filed application as the parent application. You can apply for a patent of addition at any time. So whether the parent application is pending or whether it has proceeded to grant already, you are able to lodge an application for a patent of addition. However, the period for which that patent of addition or the monopoly granted for those improvements or modifications will run for the same period as the patent of addition of the parent patent. So you aren't given 20 years from the date of application of the parent patent. Okay, the modifications and improvements will run the course of the parent patent, if that makes sense. Andreas, you look confused there. Are you on mute?
No confusion.
Okay.
I'm just saying that it does make sense.
Yeah.
You lose out.
So you don't get an extended monopoly for those improvements or modifications to the invention. It runs the same term. So the remainder of the term of the parent patent. So, if you file for this modification while the parent patent is still pending, you will still have a 20-year monopoly over those additions or modifications or improvements. But if you file for the patent of addition into the 10th year of the life of the granted patent, then your monopoly over that will only be for the remainder period, which will also be 10 years. Just looking at some of the other aspects, the formal aspects of Section 39, it says that on request, the registrar may revoke the independent patent and grant a patent of addition in respect of the addition, improvement, or modification having the same dates of application as the independent patent so revoked, and having effect from the date from which that patent had effect. So you can do away altogether with the patent, with the parent patent, and request that the patent of addition be granted instead. Then also where the patent for the main invention, or as I've referred to it, the parent patent, is surrendered, revoked, refused, or abandoned, the patent of addition shall, unless otherwise directed, become an independent patent. And the normal term of such independent patent shall not extend beyond the expiry of the patent for the main invention. So if the parent patent is lapsed, for instance, you do not pay the renewal fees on that case, or you abandon the rights to that invention or to that patent, then the patent of addition basically becomes the main patent. What's nice is that for a patent of addition, and why this is often the route taken, is that no renewal fees are payable on a patent of addition. So you don't need to pay any renewal fees for the patent of addition. But in the instance where the patent of addition becomes the main patent, then renewal fees will start to kick in, and you do need to pay your renewal fees. Then a patent of addition may also not be accepted before the acceptance of the main patent. So the patent office needs to accept them in the correct order. They need to accept the application for the main patent before accepting the parent patent, and not the other way around, just a formal requirement for the patent office. Then also looking further into Section 39, it says that the grant of the patent of addition shall be conclusive evidence that the invention is a proper subject for a patent and shall not be refused on the basis that it doesn't involve an inventive step. So for those modifications, improvements, or additions, you don't need to show that there is an inventive step in those modifications. And then also it's not possible to assign a patent of addition without assigning the parent. So they are bound by some ways. Are there questions regarding patents of addition? Okay, quite straightforward. Just important to know that you can request for patent of addition at any time in the life of the patent, of the main patents. Okay. Chris, you have a question?
Yes, Martin. The renewal, the amendment of the patent.
Chris, sorry, would you mind repeating that? The line's quite jagged.
Yeah, it's raining heavily on my side.
Okay.
The renewal fee, is that only with regards to the amending of the patent?
Yeah, so you're still paying renewal fees on the main patent. It's only for the patent of addition that no renewal fees are payable, unless it is converted into the main patent.
Okay, so it doesn't extend the period of 20 years or anything?
No, it still runs for the same duration as the main patent. So whatever the life is of the main patent, it doesn't extend it now.
Okay, so that remains 20 years.
Yeah, that's it.
Okay, thank you.
Perfect. Okay, then in terms of Section 37, provision is also made for the filing of what is referred to as a divisional patent application. You may recall the requirements that the claims of an invention may relate to one invention only, but it does often arise that there are multiple independent claims in a specification, or where multiple inventions are disclosed in invention. And in some jurisdictions, they'll raise an objection to the application containing more than one invention. So in that instance, what often happens is that the application will be divided out into separate applications, so that you have one application focusing on one of the inventions only and the other looking at the other invention. So you're dividing the initial application into two applications, but directed at different subject matter for the claims. So if let's put it in practical terms, you are filing your invention, very rudimentary example, your application for the patent that was first filed includes a claim directed to the bottle, and then also includes a claim directed to the screw top, but they're two separate inventions, okay, at the time. Both are novel, both are inventive, but it's two separate inventions, the screw cap and the bottle. So this raises what is called a unity of invention objection. There's no unity in the invention. That's separate inventions in the application. So what you'll do is that you will divide out the claimed subject matter from the already filed application to focus your claims only one application toward the bottle and the other application to the cap only. So you have two separate applications directed to different subject matter in the claims. And that way you overcome these objections of the invention not having more than one invention, or the specification not having more than one invention. So if we have a look at section 37, what it says is that where at any time after an application has been lodged at the patent office and before it is accepted, so very important to note the deadline by which you need to file a divisional application. It has to be before the acceptance of the already filed application. A fresh application is made in the prescribed manner by the same applicant in respect of part of the subject matter in the first mentioned application. The registrar may, on application made to him and in the prescribed manner before the application is accepted, direct that such fresh application be antedated to date not earlier than the date on which the first mentioned application was lodged. So when you file a divisional patent application, in the application form, you will state that it is a divisional application that stems from the parent application. You need to file it before the parent application is accepted. So before the acceptance notice is issued, you must have lodged your application for the divisional application. Then obviously paying the prescribed fees, but because it's a fresh application, you are required to antedate the filing dates of the divisional application to ensure that you still have a valid priority claim. So you're still claiming the same priority as the parent application, and you're antedating it to ensure that your priority claim is still valid. Okay, so you're just moving the filing date back to the effective filing date and not to the actual date that it's lodged at the patent office. Is everyone happy with that?
Marva, I have a question.
Yes, Jerry.
Is this the procedure followed to divide the patent, or is it often an afterthought and then they file a fresh application?
Yes.
You know, I could have perhaps lodged two applications from the word go.
Yeah.
Is that allowed? One for the cap and the other for the bottle. Or is it that I lodge one and then I thought, oh, hang on a second, I might have a problem. Let's lodge the second one and divide it. What is actually happening in real life?
Yeah, so look, it could be used as a strategy. So instead of filing 2 PCT applications, you banging more than one invention into one application and saving on filing fees during the international phase. So it could be that it's used as a strategy for those initial costs. But oftentimes, in practice, they do obtain these objections at other patent offices and then rather focus on one individual invention itself, as opposed to, having 2 banged into one application. Because although there's no remedy in South Africa for an aggrieved party to object to an application containing more than one invention. So, there's the provision that the claims may relate to one invention only. But if it doesn't, nothing can be done about that. The problem arises, though, is that when the courts need to determine what the invention is, what is the subject matter that they're actually assessing, what is a monopoly granted, it starts to blur the lines because you're leading into an issue where it's not clear what the invention is. And, the courts might find displeasure in that instance, that it's difficult for them to ascertain this. And also because the applicant is now trying to obtain a greater monopoly to multiple inventions to which they're not actually entitled for because they haven't, paid the fees to file separate applications. So again, it's a strategy thing. It also depends on the applicants themselves, how much money that they're willing to spend. But divisional applications are filed on a daily basis in South Africa.
Okay.
Okay. Neil, you have a question?
Yes, thanks. When it comes to the claims, let's say you have independent claim which relates to the secondary invention in your parent application. Then it would be fairly simple to simply delete that claim from your parent application and file it under your divisional application. But let's say it's encapsulated within an independent claim which includes both the first and the second invention. Would you amend that claim or would you leave that claim as is? Because let's say the divisional application for some reason doesn't proceed to grant, at least then you still have your parent application.
Yeah, look, that's a tricky question. The only requirements, because the requirements aren't very clear as to what the divisional claims need to look like. But there was the case, you can see it's on the slide, to the Pharmadynamics case. And in that case, it basically just held that the claims cannot be the same. There may be overlap of the claims, but they cannot be the same. So I think that does answer your question where, an independent claim relates to 2 various embodiments or 2 inventions. It is permissible to have one that includes both and the divisional application that only includes one, because they're not the same claims, but there is overlap and the overlap is permissible.
Thank you. Yeah, that answers my question.
Okay. Yeah, so I mean, if you look here, what was held in this Pharmadynamics case, it says that the claims of divisional application must not be coterminous. I don't know why they use this wording. Who knows what that means? But the interpretation is that coterminous is that their claims may not be the same as the parent, but that the claims of the divisional application can overlap with those of the parent application. And it's also possible for it to have a broader scope as the parent. Okay, then it's also not possible for the parent patent to be considered novelty destroying against the divisional application. I mean, that pretty much goes to speak for itself, but it is set out in section 37, subsection 2.
Can I also ask one question there, please?
Yes.
Thanks. If this division of patent, it becomes interesting. If the primary patent or the initial submission now is filed, let's assume there is a kind of joint collaboration with different team members, and then you want to file in which you carried out the first aspect of the patent with some colleagues, and then the other one with some other colleagues. Are you seeing any problem there if you are trying to file these under this type of divisional application? Are you seeing any issues around that?
So what's, if I understand correctly, it's where there's been a collaboration on what's disclosed in the parent application, but then subject matter from only one research is only claimed in the second application.
Can you come again? The network was a little bit bad.
So my understanding is that the subject matter that's disclosed in the parent application was a collaboration by 2 institutions. But
yes,
when you file the divisional application, what you are claiming relates only to subject matter which was contributed by one of the institutions only.
Yes.
Okay. So if you look at section 37, it says that the divisional application must be made by the same applicants. And the problem is, well, it's not really a problem. What happens in practice is that the same description is filed for the divisional application. It's only the claims that differ. Okay, so the description, the entire disclosure, except for the claims, are the same between the first filed application, your parent application, and your divisional application. And because of that disclosure, there's a contribution by the inventors, which are either employed by both applicants of the main invention. That disclosure sits within both applications, in both the parent and the divisional application. So unlike with America, so America, for instance, inventiveness, or the inventorship, not inventiveness, inventorship, who invented the invention, is tied with the claims. Okay, so what is claimed and what is claimed is linked to the inventors. I don't want to lose you, yeah. But in South Africa, inventorship is dealt with differently. Inventorship in South Africa looks at the inventive concept as a whole. So the entire disclosure, not necessarily only to what is claimed. So because the disclosure is the same in both the parent and the divisional in terms of the description, and the contribution of the inventive concept is devised by inventors of 2 collaborators, then both applications should have to be filed in the name of both applicants from the original application. Does that answer you? Do you hear me?
Yeah, I'm not sure if you can get me, but I think I captured what.
Okay. Yeah.
Hello, can you hear me?
I can hear you.
Yes, I'm saying towards the end, it becomes a little bit bad in terms of network here. But I could understand that you said the application itself, maybe the primary application, had to contain the entire list of the collaborators from both institutions. Yeah.
That's correct. Yeah.
Right.
Look, and I mean, it's prescribed that the divisional must be filed by the same applicant, which you can do. If that subject matter is excised from the divisional application by way of an amendment and it's deleted, and there's really nothing that the inventors of the second collaborator actually contributed towards and they're not entitled to it, then you can amend it to remove that co-applicant. But it's very unlikely that that would be the situation. Okay.
Okay.
A good question. A very good question.
We can amend the divisional. We can amend the divisional to remove the name of authors that are not contributory, maybe in that aspect.
That's correct, but you'll have to be 100% certain that there was no contribution by the inventors of the second collaborator to any inventive concept related to the invention.
Oh, that's okay. That's okay. I got that one. Thank you.
Okay.
Hi, Marco.
Yes, Jay.
The publication in the journal, does it actually contain the complete specification, the description, the claim, everything?
No, not at all.
How would, I mean, I haven't found one yet, but is it fairly easy to find one on the internet? If I search for one, or is there something you can share with us for the class?
So, look, they don't necessarily publish the entire specification, so you'll actually have to draw the file from the patent office to get access to it. I see that they are starting to publish more and more things on the register itself. So I can provide you with a link to the website where the registrar is and where you can access the applications and the granted patents. But it's not to say, it's not to say that that the full specification will be published online.
Okay, yeah, just to get a sense of what is the description, what is the claim, and those sort of things.
I can share a specification with you easily. That's no problem. I'm happy to do that.
I've put the link on in the chat box.
Thanks, Andres.
Thanks,
thank you. But
my pleasure.
I mean, a lot of the South African applications will be national phase applications, and that you can get from PCT's website as well. The specification. The only problem is that a lot of the specifications are amended in South Africa before they go to grant. And I can guarantee you that that isn't published on CIPC's website. You'll have to pull the files to see those. But yeah, I'll pull up a specification and I'll share it with the group, hopefully by tomorrow's lecture, that we can have a look at it.
Yeah, thank you.
Just so you can get a sense of the format. Okay, and that basically covers divisional patent applications and for purposes of this module. And the thing is, these divisional applications, once they're granted, they have a separate life to the patent, the parent patent. It's a separate application number that's issued. Renewal fees are payable on the divisional patents. You know, you can enforce them separately. So, you know, unlike with the divisional, unlike with the patent of addition, where, you know, there is some tie between the two. Okay. In terms of section 46(1), we know now already that a South African patent has a lifespan of 20 years before it expires, subject to the payment of the prescribed renewal fees every year from the third year. So let's have a look at the renewal fees briefly. Then we should end off today's lectures relatively soon. So the renewal fees in most instances are payable from the third year of the filing dates of the application. So from the third year, that's 36 months. from the date of filing the application. But now it's important to distinguish what is considered to be the effective filing date. As you'll recall, we discussed earlier, for a convention application in terms of the Paris Convention, an application filed directly into South Africa or by local applicants in South Africa, it's the lodging date. So the date you actually submit the application to the Patent Office. For a national phase application, it's the international filing date. So your renewal fees deadline is calculated from the international filing date for national phase applications. Okay, in all other instances, it is from the local filing date. So be very cognizant as to when these deadlines run from and what is deemed to be the effective filing date. If we have a look at section 46.2, it basically just provides that there is a 6-month grace period available to the patentee within which to pay the renewal fee. So if we have a look at the timeline, the application was filed in this instance in South Africa on the 10th of January 2020. It proceeded to grant 3 years from the application date, the first renewal fee is due. That is by when you should pay the first renewal fee. Okay, but in terms of section 46.2, a 6-month grace period is available to the patentee upon request. So you actually need to request that you be granted the 6-month period and pay the late fines for the renewal of the patent. Okay, quite straightforward. Let me just have a look at my notes briefly again, yeah. Okay, in terms of Regulation 48, where grant occurs more than 3 years from the application date, the first renewal fee is then due upon grant. So if we go back to the previous slide, you can see this application proceeded to grant before the first renewal fee was due. But in this instance, you can see 3 years have passed and the application has not yet gone to grant. That renewal fee that would ordinarily have been due within 3 years only becomes due upon grant of the application. Okay, so any renewal fees that were previously outstanding that would have been due during the pendency of the application is payable upon grant. Again, that 6-month provision in terms of section 46.2 is applicable in instances such as these. Okay, in terms of Regulation 67L, Section 67L is only applicable to national phase patent applications, and this can be quite a mouthful as well. So I'll try to digest it and give you a concise explanation as to what it means. But let's go through it together. So if a patent issues on an application filed in terms of Section 43, so that is relating to national phase applications, 3 months or more before the expiration of 36 months from the international filing date, Regulation 48 shall apply. What this basically says is if you filed a national phase application and proceeds to grant within 33 months from the international filing date, then the renewal would fall due as it ordinarily would for an ordinary application. So upon the 3rd year and a 6-month extension is possible to pay the late fine. So in this case, quite straightforward. However, it goes on further to say that if a patent issued on an application after the expiration of 36 months from the international filing date, or less than 3 months prior to such expiration date, the patentee shall pay any renewal fees payable in terms of Regulation 48(1) within 6 months of the date of publication in terms of Section 42, or such further period as the registrar may, in terms of the provisions of Section 43(2) and on compliance with 43(8) allow. So in this case where a national phase application proceeds to grant after 33 months, then any renewal fee that would ordinarily have been due is given a 6-month grace period without any request for an extension of fines and an additional 6 months. So you basically have a year within which to pay those renewal fees in the instance where the application proceeded to grant more than 33 months from the date of the international filing date. I hope that's clear to everyone. So, just to be concise again, if grant occurs for national phase before 33 months from the international filing date, then the renewal fees are due as per usual. On the third year, your renewal fee is due, and the 6-month grace period is also available to the patentee. But if grant occurs more than 33 months from the international filing date, then the patentee is provided a 6-month grace period with no fine payable within which to pay that renewal fee, but there's also an additional 6-month grace period with a payment of a late fine. So you have a year then within which to pay that renewal fee. And this is just looking at those two examples. And that brings us to the end of the procedural chapter on patent applications and patents for today. Are there any questions that you may have for me?
Yeah, on my side, it's not a question, but I just want to, on behalf of everyone, say thank you for the time, and we look forward to a more beautiful session tomorrow.
It's only a pleasure, DMA and everyone. I do appreciate it. Yeah, if you have any suggestions, if I'm going too fast, if I need to clarify anything, please do let me know. I'm happy to take your suggestions and criticisms on board. Okay. Colin has a question. Thanks. Please let us know if there's an alternative link for recording. As I mentioned earlier, the recording will be placed onto YouTube. If that isn't suitable, then please let me know, Colin, and I can see what else can be done. Okay, perfect. So YouTube will be fine. I'll hopefully upload that by early next week for today and tomorrow. Thank you, everyone. Have a restful evening. Please come back tomorrow recharged. We have another great session ahead of us tomorrow. And if you do have any questions, please feel free to pop me an email, or we can just touch base tomorrow morning when we start our second day of the workshop. Thank you, everyone. And then I'll see you at the same time tomorrow. Thank you.
Thanks, Marco.
Thanks.
Thank you, Marco.
Thank you.
Thanks.
Goodbye.
Thank you so
Bye.
much.
Pleasure.
Thank you. Bye.